Somewhere right now, someone is sitting in front of a glowing inbox that was never supposed to be theirs, weighing 3 seconds of curiosity against the rest of their life. Here's the part almost nobody sees coming. Reading a private email you technically have access to might not be a crime at all. Hitting forward on it can end a career, drain a savings account, and in some cases put a person in a courtroom on charges that have nothing to do with hacking whatsoever. The button that ruins everything was never open, it's send. Welcome to Catastrophe Theory, where we figure out exactly how fast your life falls apart if you actually let the intrusive thoughts win. I'm CJ Theory, and today we're looking at what happens when you finally listen to that voice in your head and forward your boss's private emails to the last people on Earth who were ever supposed to read them. You're still logged in. That's the detail nobody plans for. You went looking for a shipping confirmation or a signed contract or a file your boss asked you to track down at 4:58 on a Friday afternoon, and now you're staring at a subject line you were never meant to read. Maybe it's a message to HR that happens to mention your name. Maybe it's a thread with another executive making it clear that the layoffs everyone swore weren't coming are already scheduled, quietly, for next quarter. Maybe it's simpler than that. Maybe it's just personal, messy, human in a way you didn't expect from someone who signs your paychecks and lectures you about professionalism. Your hand is on the mouse, the cursor is sitting on forward. You can feel your own pulse in your fingertips, which is a strange thing to notice about yourself in an office that's gone silent except for the hum of the air conditioning and the small, insistent voice in your head that's already drafting the message you're about to send. You glance at the door out of habit, even though you know it's well after 6 and the only other car left in the lot belongs to the cleaning crew 2 floors down. The screen brightness suddenly feels too high, like it's broadcasting what you're doing to the whole building. Your own reflection sits faintly in the monitor glass, layered right over the sentence you can't stop rereading. And for one disorienting second, you're watching yourself watch something you shouldn't be looking at, which is its own strange, specific kind of vertigo. You tell yourself you're just going to look. You tell yourself you deserve to know, considering everything you've put up with. You tell yourself that whatever happens next isn't really your fault because you didn't go looking for this. It simply appeared in front of you. And now that it has, doesn't the truth have a way of getting out into the light? That thought, doesn't the truth deserve to get out, is doing a lot of dangerous work in your head right now. It is the exact thought that convinces smart, careful, otherwise reasonable people to do something they will spend years trying to undo. I've spent a long time on the other side of that decision, not as the person who hit send, but as the one who talked to them afterward. A former executive assistant who found out her boss had been lying to the board for a year and paid a legal bill larger than her old salary to learn that being right didn't matter nearly as much as she thought it would. A mid-level manager who forwarded 3 sentences of a private conversation to just one coworker and watched that one coworker become 11 people within a single afternoon. An IT contractor who still, years later, won't say the company's name out loud in casual conversation. Names changed, identifying details combined and altered, but the shape of the story doesn't change no matter who's telling it. Someone found something in an inbox they had every technical right to be inside of and absolutely no legal or professional right to share, and for one adrenaline-soaked window of time, that distinction stopped mattering to them completely. This isn't a video about whether your boss deserves it. Sometimes they do. Some of what people find in these inboxes is genuinely, seriously wrong and deserves to see daylight through the right channel. This is a video about what actually happens to you, mechanically, legally, professionally, and psychologically, the moment you decide your own judgment about what deserves to get out outranks every law, contract, and boundary standing between you and that button. I'm not here to tell you what your boss did or didn't deserve. I'm here to make sure that whatever you decide it with your eyes fully open, instead of finding out what was actually at stake for the first time in a lawyer's office. Because here's the thing nobody tells you about intrusive thoughts. They don't feel intrusive while you're having them. They feel like clarity. They feel like courage, maybe even, like justice finally arriving on schedule. It's only afterward, in the deposition, in the unemployment office waiting room, in the silence of a group chat that stopped including you somewhere along the way, that they start to feel like exactly what they always were. So let's take this apart slowly, mechanically, the way it actually unfolds rather than the way it feels like it's going to unfold in the 2 seconds before you do it. Because the story actually doesn't start with the forward button. It starts about 90 seconds earlier in a part of your brain that was never designed to make decisions with this much weight riding on them. Think of your prefrontal cortex as a security guard stationed at the door of every action you're about to take. His entire job is to check the identification of an impulse before it's allowed to become a behavior. Is this a good idea? Will you regret this in 6 months? Does this match who you actually want to be once the adrenaline wears off? Most of the time, that guard is doing his job so constantly and so unremarkably that you never even register he's standing there. But that guard has a weakness, and it's the same weakness every security system has. He gets slower and considerably more distractible the more chaos is happening around him. Anger does that to him. Humiliation does that to him. The specific personal sting of realizing someone you trusted was speaking about you the way you just read on that screen, that does it faster than almost anything else a workday can produce. Researchers who study decision-making under emotional load call this a hot state, as opposed to the cold state you happen to be in right now, calmly watching a video about someone else's worst afternoon. In a hot state, the guard is technically still at his post, he's just not checking identification very carefully anymore. Impulses that would normally get turned away, questioned, sent back for reconsideration, sail right through wearing almost no disguise at all. There's a reason this particular kind of discovery hits harder than almost any other workplace frustration. Human brains carry a strong negativity bias, tuned by a long evolutionary history to weight social threats, being talked about, being excluded, being judged behind your back, far more heavily than neutral or even positive information. Finding out your boss described you unfairly in a private message doesn't register the way an ordinary annoying email does. It registers the way a threat does. Because on some old, unglamorous level, that's exactly what your nervous system has decided it is. The guard isn't just distracted in that moment. He's being told urgently and incorrectly that this is an emergency requiring an immediate response, when almost nothing about a private email actually requires one. This is why the decision to leak something rarely happens the way people imagine it would, in the calm, planned-out version they picture in advance. It happens in the 90 seconds after the discovery, while the guard is still catching up to what's going on, which is exactly why almost everyone who has actually done this describes the same sensation afterward in almost identical language. It didn't feel like a decision, it felt like something that happened to them, the way weather happens to you. It wasn't. It was absolutely a decision. It was simply made by the part of you that was never supposed to be making decisions with this much downstream consequence attached to it. And by the time the security guard shorts himself out, gets back to his post and says, "Wait, hang on, let's actually think about this," the email is already gone, and it is not coming back. And once it's gone, you stop dealing with your feelings, you start dealing with infrastructure. Here's what almost nobody understands about a sent email. It was never really sent in the way a paper letter is sent. It was copied. Every time you forward a message, you're not moving it from one place to another, you're duplicating it. And every copy carries a small trail of information describing exactly where it came from. Headers, timestamps, routing data bouncing between servers, the digital equivalent of handling something without gloves and leaving prints on every surface you touched. It's worth sitting with how strange this actually is, historically speaking. For most of human history, betraying someone's private correspondence took real physical effort. You needed access to a locked drawer, a filing cabinet, an office after hours. You needed to photocopy something or steal the original and hope nobody noticed it was gone. And then you needed an actual method of distribution, the mail, a journalist, a bulletin board. Every one of those steps was a chance to reconsider.
matter. Everyone was friction, and friction is exactly what gives the cold, careful part of your brain time to catch up with the hot, impulsive part that wants to act right now. Email deleted nearly all of that friction in one stroke. The distance between "I found this" and "everyone has this" collapsed from days or weeks down to the time it takes to move a cursor 3 inches and click once. None of that exists specifically to catch you. It's simply what email is underneath the interface. It's plumbing, and plumbing keeps records, whether or not anyone happens to be watching in the moment. Most companies of any real size also run something called data loss prevention software, a considerably less dramatic name for a system that is constantly watching for exactly this kind of movement. It flags messages leaving the network that contain certain keywords, certain attachment types, certain unusual patterns of behavior. A message from a mid-level account suddenly forwarding a thread that involves a senior executive, for instance, is precisely the shape of activity these systems exist to notice, not because your company suspected you personally in advance, because it suspects everyone all the time by design, the same way a smoke detector doesn't know your name and doesn't need to. You don't need to be caught by a system built specifically to catch you. You only need to be caught by a system built to catch anyone. And in most modern offices, that system is already running in the background of a workday nobody thinks twice about. So what actually happens once someone notices? Let's walk through it. The moment your boss or their assistant or their lawyer or a coworker who got forwarded the message and immediately panicked and told somebody realizes what's happened, a process starts that most people have never seen from the inside, because most people, understandably, have never needed to. First, it goes silent. That's the detail that catches everyone off guard. Companies do not confront you in the moment the way it happens in movies. They pull records first. IT receives a request, usually within hours, to preserve email logs, login timestamps, and access history tied to a specific account. HR opens a file without a word to anyone outside the room. If the leaked material touches on anything with real legal exposure, financial disclosures, personnel decisions, ongoing litigation, outside counsel gets a phone call, sometimes before the end of that very same day, long before you've heard a single word about it. This step even has a formal name, a litigation hold. It's an instruction that freezes the normal routine deletion of data, the kind that would otherwise clear out automatically after 90 days, because the company now anticipates this might end up in front of a judge eventually, and destroying potential evidence at that point creates an entirely separate legal problem of its own. Every account even loosely connected to the leak, including yours, gets preserved in place, frozen, waiting. And here's the detail that makes this stretch of time genuinely difficult for the person on the other end of it. You usually have no idea any of this is happening yet. You keep showing up to work. You keep making small talk by the coffee machine with the exact people quietly building a file on you. The silence isn't mercy, it's process. What they're doing mechanically is narrowing a room. Think of it less like a security camera catching a face in a crowd and more like a locked room mystery. How many people had access to this specific inbox at this specific time with this specific level of permission? In most offices, that number is dramatically smaller than people assume it is. An executive's inbox isn't read by hundreds of people. It's read by a handful, an assistant, perhaps an IT administrator, perhaps 1 or 2 direct reports with delegated access for scheduling purposes. When the pool of suspects is 5 people instead of 500, an investigation stops being detective work in any dramatic sense and starts being simple arithmetic.
This narrowing is usually finished within days, not months. And here's the detail that catches nearly everyone off guard every single time. The leak itself is rarely what actually gives someone away. It's everything they do afterward. The nervous phone call to a friend placed from a work laptop that logs activity in the background without asking permission. The panicked group chat message screenshotted by someone who didn't feel quite as loyal as expected. The late-night search typed from a personal phone connected to the office Wi-Fi out of habit, asking whether forwarding an email can actually get someone in trouble. You are, in that moment, doing exactly what almost every person under sudden stress does, trying to manage the fallout using the same instincts that got you into the situation in the first place. It rarely goes better the second time around. And once your name is the only one left standing in that narrowing room, you stop being an employee with a grievance, you become a legal problem with a job title, and every conversation from that point forward gets handled accordingly. This is where I want to slow down because this is the part almost every other video on this subject gets wrong. They treat getting in trouble as one single undifferentiated bad outcome, a wall you either hit or you don't. It isn't that simple. It's actually several separate systems running on separate timelines, and they tend to arrive in a very specific order. The first is almost immediate: termination. In the overwhelming majority of employment situations, you do not need to have broken a single law for a company to end your employment over this, the same day they confirm what happened. Confidentiality is written into most employment agreements as a basic condition of the job itself, not some optional add-on reserved for sensitive roles, which means a company doesn't need to prove you committed a crime in order to decide you're no longer welcome in the building. This part takes hours, sometimes less. There's rarely a severance package waiting on the way out either. Most severance is offered at a company's discretion as a goodwill gesture or to secure a signed release, and companies tend to have very little goodwill left over for the person who just handed their private correspondence to someone else. The second is civil, and it's the one people consistently and dangerously underestimate. Even when no criminal law was technically broken, you can still be sued for breach of contract if you signed a confidentiality agreement, which most people working anywhere with something worth protecting eventually have, often without reading it closely. For breach of a duty of loyalty, if your role gave you any real position of trust. For invasion of privacy, under a specific legal theory that many places recognize as its own category of harm, the public disclosure of private facts, entirely separate from whether those facts happen to be true. And truth, in this particular corner of the law, is not the shield most people assume it is walking in. A private, personal email can be completely, verifiably true and still cause a legal, compensable harm the moment it's exposed to people who never had any right to see it in the first place. It's worth pausing on one detail almost nobody thinks about until it's too late. The people you send it to aren't necessarily safe either. A coworker who receives a forwarded private email and then reads it, keeps it, or passes it along again has, in that moment, also received information they had no right to have. Companies investigating a leak routinely pull in everyone who touched the material, not just the original source, and "I didn't leak it, I just got sent it" is a considerably weaker position than most people assume walking in, especially for anyone who forwarded it even once more. The circle of people whose lives this touches is almost always wider than the one person who hit the button first. The third is the one people fear the most and, ironically, the one that actually applies the least often anymore: criminal liability under something like the Computer Fraud and Abuse Act. And here I want to be precise because a 2021 Supreme Court decision changed this landscape more than most people realize. The case was Van Buren versus United States, and it involved a police officer who looked up a license plate in a database he was fully authorized to use for a personal reason he was never authorized to have. In a 6-3 ruling, the court decided that misusing access you already legitimately hold isn't the same thing legally as exceeding authorized access under federal computer crime law. In plain terms, if you had a genuine work-related reason to be inside that inbox in the first place, reading something personal while you were already legitimately there probably doesn't make you a federal criminal on its own. I want you to notice that I said probably, and I want you to notice that this is not nearly the relief it sounds on first hearing. Van Buren narrowed one specific federal door. It did not close any of the others standing next to it.
State-level computer crime laws vary considerably from place to place, and wiretapping and interception statutes operate under an entirely different legal theory than access statutes do. And depending on exactly how information was obtained, intercepted in transit versus found already sitting in storage, they can apply in ways federal computer fraud law never touches. And civil liability, the lawsuits, the settlements, the actual money changing hands, was never touched by that ruling at all. It was never what that case was about. So the real shape of the danger here isn't "you'll go to prison." For most people, in most everyday situations, that was never the realistic outcome to begin with. The real shape of the danger is slower, quieter, and in its own way, more thorough. No job, a legal bill that starts at a number most households don't have sitting comfortably in savings, a settlement agreement with restrictions you'll be living inside of for years afterward, and a professional reference that, if you're lucky, simply confirms your dates of employment and says nothing further, which, in most industries, functions as its own red flag to anyone experienced enough to recognize the silence for what it is. And there's a longer tail to this that almost nobody talks about because it doesn't fit neatly into a headline. Industries are smaller than they look from the outside. The person who hires your eventual replacement may have worked alongside your old boss for a decade. The recruiter who calls you 18 months from now about a job that sounds perfect may make exactly one phone call to someone who was in the room the week everything happened. None of that requires a lawsuit or a criminal record to follow you. It just requires people to remember. And in most professional worlds, people remember exactly this kind of thing for a remarkably long time. What started as 90 seconds of adrenaline in front of a screen can end up shaping a decade of closed doors you never actually see closing because nobody ever tells you a door was open in the first place. There's also a cost that never shows up on any legal document, and it tends to be the one people underestimate most going in.
Litigation, even the kind that eventually goes your way, is slow in a way that's genuinely hard to describe until you're living inside it. Months of waiting between filings, depositions scheduled and rescheduled, a lawyer's invoice arriving with the same grim regularity as a mortgage payment. People who go through this describe a specific low-grade exhaustion that seeps into everything else: sleep, relationships, the simple ability to enjoy an ordinary Tuesday. You don't get to compartmentalize a lawsuit. It rides along in the passenger seat of your entire life for as long as it takes to resolve, and these things rarely resolve quickly. So, if you've made it this far, I already know what you're thinking, because I hear some version of it every single time this subject comes up. You're thinking, but what about the times it's actually justified? Good question. Let's talk about that directly, because there are more myths tangled up in this particular topic than almost anything else I cover on this channel, and some of them are dangerous enough to get well-meaning people seriously hurt. Most of these myths don't come from nowhere. They come from workplace folklore. A friend of a friend who did something similar and, as far as anyone knows, faced no consequences at all. What that story almost never includes is the part where nothing has happened yet, or the settlement that came with a confidentiality clause preventing anyone from ever discussing it, or the fact that people who genuinely got away with something quietly have a very strong incentive to stay quiet about that too. Survivorship bias is doing an enormous amount of work in the version of this story that gets passed around at happy hour. Myth 1. If you didn't hack anything, you didn't break the law. Reality? This is precisely the myth that the Van Buren ruling complicates rather than resolves. Yes, misusing access you already legitimately have is less likely to trigger federal computer fraud charges than it used to be. But not a federal computer crime and legal are two entirely different categories, and collapsing them together is exactly how careful people talk themselves into catastrophic decisions. Breach of contract doesn't care whether you hacked anything. Breach of a confidentiality agreement doesn't care whether you hacked anything. A civil claim for invasion of privacy doesn't care whether you hacked anything. You can do all of this without writing or exploiting a single line of malicious code and still lose your job, your savings, and years of your life to litigation over it.
"I didn't hack it" has never once been a complete defense in any court, because hacking was never the only law standing in that room. Think of it this way. Unauthorized computer access is one lock on a very long hallway of doors, and the Van Buren ruling only ever addressed that first lock. Every other door down that hallway is exactly where it always was, and most of them were never secured with anything resembling a computer crime statute to begin with. They were secured with a signature you provided yourself on your very first day at the job. Myth 2. This counts as whistleblowing, so I'm protected. Reality, whistleblower protection is one of the most specific, narrowly defined categories in all of employment law, and it exists to protect a very particular kind of disclosure, one made in good faith about a genuine legal violation, fraud, or danger to public health or safety, and critically, made through appropriate channels, a regulator, an inspector general, a compliance office, sometimes a specific hotline built for exactly this purpose. It was never designed to protect forwarding an embarrassing or purely personal message to coworkers, a group chat, or a public forum, no matter how satisfying it feels in the moment it happens. If what you found is genuine evidence of fraud or illegal conduct, there is very likely a protected, legally sound way to report it, and an employment attorney can point you toward it in a single conversation. Screenshotting your boss's messy personal life and sending it around the department is not that, and no amount of moral certainty converts one into the other. Myth 4. If you stay anonymous, they'll never trace it back to you. Reality, we've already walked through why this rarely holds up. When the pool of people with access to a specific inbox is small, and it almost always is, anonymity isn't the fortress people picture in their heads before they act. It's a locked room with 5 names written on a whiteboard, and investigators, lawyers, and IT departments are very good at arithmetic, because narrowing that room is quite literally their job. Add to that the digital trail that modern communication leaves behind by default, metadata, login timestamps, device fingerprinting, occasionally even writing style analysis in more serious cases, and anonymous usually just means not yet identified, which is a considerably shorter-lived condition than most people assume going in. Even the timing of when a message was opened, forwarded, or first appeared outside the company can narrow a window of suspicion down to a single afternoon, which is a much smaller haystack to search than most people imagine when they're deciding whether to hit send. Myth 5. If it's true, it can't really be that illegal. Reality, this is most likely the most seductive of the 4 because it feels morally obvious on its face. Truth is supposed to be a defense, and it is, specifically for defamation in most places, because you generally cannot defame someone with an entirely accurate statement. But privacy law and defamation law are not the same law, and this is exactly where the trap is set. You can say something completely, verifiably true about a person and still be liable for how you obtained it, how you chose to disclose it, and the harm that disclosure directly caused, especially when the information was genuinely private, unrelated to any matter of legitimate public concern, and taken from a source you only had access to because of trust, not because of any permission to go and share it further. Truth protects you from exactly one specific legal claim. It does nothing at all against several of the others waiting behind it. Courts have in fact ruled against people for publishing information that was entirely, verifiably accurate, precisely because accuracy was never the question being asked. The question was always whether the information was theirs to share in the first place. Myth 5. My company is too small to actually investigate something like this. Reality, this used to be truer than it is now, and that gap is closing fast. Most small and mid-sized companies don't run their own email servers anymore. They use a cloud provider, which retains detailed audit logs by default, who accessed what, when, from where, without requiring a single in-house security specialist to set anything up. Pulling that history is often a matter of an administrator submitting a routine request, not commissioning a forensic investigation. The absence of a dedicated IT security department doesn't mean the absence of a paper trail. It just means the paper trail is sitting with a provider instead of a server down the hall, which for the person being investigated amounts to exactly the same problem.
So if you're standing at that inbox right now, or if you've already been there and you're watching this trying to work out exactly how much trouble you're actually in, here's what I want you to do instead. Not what I wish you had done, what to actually do starting from this moment forward. 1. Close the window, not metaphorically. Physically stand up, walk away, and put at least 24 hours between the moment you found something and the moment you decide what to do about it. Every single person I've ever talked to who regrets what they did made that decision inside the first hot, adrenaline-soaked hour after finding it. Nobody I have ever talked to regrets waiting a day. 2. Ask yourself honestly which situation you're actually in. Did you find real evidence of something illegal, fraud, harassment, safety violations, discrimination? Or did you find something personal, embarrassing, and simply human that mostly confirms your boss is a flawed person like everyone else on Earth? These are not remotely the same problem and they do not share the same solution, so be genuinely honest with yourself here, because every step after this one depends entirely on getting this first one right. If you're not sure which one you're looking at, that uncertainty is itself useful information. Genuine wrongdoing tends to feel clear once you say it out loud to someone you trust, while a personal grievance tends to get muddier and more complicated the more you try to explain it. 3. If it's the first kind, real, provable wrongdoing, do not forward it to coworkers, do not post it anywhere, and do not confront anyone directly with what you found. Go to an employment attorney first, ideally one with whistleblower experience specifically, many of whom offer a free initial consultation for exactly this reason, because they would rather catch people before this mistake than untangle it afterward. They will walk you through the legally protected way to report what you found, which almost always exists, and which protects you far more thoroughly than forwarding an email ever could. 4. If it's the second kind, personal, not criminal, sit with the fact that no law exists to protect you here, and no amount of moral certainty changes that underlying reality. The instinct to expose it is almost never really about the content itself, it's about something underneath it, feeling disrespected, feeling unseen, feeling like the power in this particular relationship has been unfairly stacked against you for a long time. That feeling is completely real, and it deserves to be taken seriously. Leaking a private email will not resolve it, and in nearly every documented case, it makes the underlying problem measurably worse. 5. Go find out exactly what you actually signed. Most people have no real idea what's written into their own confidentiality agreement, their offer letter, or their company's IT acceptable use policy until the exact day they desperately need to know. Request a copy today. Read it before you do anything else, not after the fact when it's too late to change your decision. Most of these documents are written entirely in the company's favor, naturally, but knowing exactly where the lines are actually drawn still beats guessing at them under pressure. 6. If you've already sent something, if this checklist has found you too late to prevent it, stop immediately. Do not send anything else. Do not explain yourself in writing to anyone, including close friends, including a group chat you trust completely. Every written explanation becomes another document someone else can eventually be shown. Contact an employment attorney today, not after you've already been confronted about it. The instinct to apologize, to explain, to make it right on your own terms is completely understandable and almost always makes your legal position worse, not better. 7. Separate the legal problem from the emotional one and get real support for both, ideally from two different people.
A good lawyer can protect your record and your finances. They cannot fix the underlying reason you wanted to detonate your professional life in the first place. That part deserves its own genuine attention, ideally from someone who isn't billing you by the hour to hear about it, a therapist, a trusted friend outside the industry, someone whose job isn't managing your legal exposure, but simply helping you understand why one email made you willing to risk everything you'd built. 8. If the workplace itself is the actual ongoing problem, not one email, but a pattern, a culture, a boss who makes the job genuinely unbearable to show up for, start documenting that pattern through channels that actually protect you. Dated notes written to yourself, formal HR complaints on the record, written concerns sent through the proper internal process. A boring paper trail built patiently over months protects you in ways a single dramatic leak never ever will. 9. Remember that leaving is always sitting there on the table, and it's almost always the option people completely forget to seriously weigh while they're standing frozen at that inbox. A resignation costs you a few uncomfortable weeks and an awkward conversation. A leak can cost you years you will never get back. 10. If you're already sensing that an investigation might be underway, colleagues acting strange, a sudden meeting request from HR with no agenda attached, do not walk into that meeting alone and unprepared, and do not assume friendliness means safety. You are allowed to say you'd like counsel present, or that you'd like a day to gather your thoughts before answering questions. That is not an admission of anything. It is exactly what anyone with something real at stake should do, and any HR department that has handled this before will not be even slightly surprised to hear it. I know how that list probably sounds. Careful, a little unsatisfying even. Nobody clicks on a video like this one hoping the ending is consult an attorney and give it 24 hours, but I would much rather hand you something unsatisfying that actually works than something cathartic that quietly ends your career while it's still playing out in your head. Here's what I actually think, underneath all of the legal detail we just walked through together. The fantasy of leaking something was never really about the email itself. It's about power. Somewhere in that hot 90-second window, leaking feels like the one move still available to a person who otherwise feels completely without leverage, underpaid, unheard, managed by someone who appears to hold every card in the relationship at once. For one adrenaline-soaked moment, hitting forward feels like finally holding a card of your very own. I understand that fantasy completely. I'd be lying if I told you I've never felt some version of it myself, sitting in some job, staring at some message I was never supposed to see in the first place. It is an extremely human thing to want the people with power over your life to be seen clearly, honestly, and completely for once, by everyone around them.
None of this is new either, even though the tools are. People have always stood at the edge of someone else's secret, wondering if exposing it would finally balance some old private scale. What's changed is only the mechanism. A diary used to require someone to physically break in and read it by hand. Now it only requires a password you already legitimately have and a decision that takes less time than it took you to read this sentence. The temptation itself is ancient. The speed at which you can now act on it is the only genuinely new catastrophe in this whole story. But here is the reframe I actually want to leave you with, because I think it matters more than any legal detail we've covered today. The confidentiality that makes this all so frustrating in the moment, the walls, the agreements, the quiet professional boundary between what's technically yours to know and what was never meant to be shared, is the exact same infrastructure that protects your own private words on the one day someone else happens to be angry enough at you to want them exposed. It isn't a wall built specifically to protect the powerful. It's a wall built to protect anyone whose private thoughts could be taken out of context and weaponized by somebody who simply happened to have access on the single day their own judgment failed them. You benefit from that exact wall constantly, in every job you will ever hold, in ways you will probably never even notice, because it's doing its job exactly as intended. That's not an especially cinematic answer to the question of what happens if you leak your boss's private emails. It won't trend anywhere, but it happens to be the true one.
and the true one is usually what keeps a person's actual life intact. So the next time that thought shows up uninvited, the one that whispers, "Doesn't the truth deserve to get out?" I want you to recognize it clearly for exactly what it is. Not clarity, not courage, just a security guard momentarily distracted by something loud and personal, letting an impulse through that deserved a much longer look than 90 adrenaline-soaked seconds could ever give it. Whatever you decide to do with what you found, decide it as the version of yourself who has to live with the outcome for the next 10 years, not the version who's been awake since 6 a.m. and just found out something that hurt. Those two people rarely want the same thing, and only one of them has to deal with what happens next. Close the laptop, take the day, and let the ordinary version of your career, the one where you show up again tomorrow, still employed, still trusted, still boringly, wonderfully unremarkable, stay exactly, completely that ordinary. But that's just a theory, a Catastrophe theory. Thanks for not ruining your life.